Greetings, Sanbonani, Dumelang. Greetings, guys. How you guys doing, Ninjani? I'm well, thanks, guys. First of all, guys, I just want to apologize that I haven't posted any video in about a week's time or more than a week. Reason being is because we do not have power this side. We've been without power since the Sunday, the 19th of November. Even as we speak now, right now, we still do not have power. So, yeah, it's a bit of a struggle to charge devices and stuff like that. So, apologies for that, guys. But now I'm back. Uh, just want to thank you guys, those who have been watching the channel, watching the videos, commenting, and those who have subscribed. Thank you very much, guys. Please continue doing so, guys. All right, guys, let's jump into it. We're still doing the CCMA rules that were released in April this year. We've done 4 parts. Now we're going to do the 5th part of the CCMA rules, guys. Okay, let's get into it, guys. Part 5, rules that apply to conciliation, arbitration, con-apps, and other processes where a hearing will take place. Number 1, a dispute must be heard in the region in which the cause of action arose or where the employer's principal place of business is located, unless a senior commissioner in the head office of the commission directs otherwise. Number 2, the commission or commissioner within a region determines the venue for the hearing, which venue may include online hearing held via a digital platform. Representation before the commission. Very important, guys. Pay attention to this. Number 1A. In conciliation proceedings, a party to the dispute may appear in person or be represented only by, number 1, if the party is an employer, a director or employee of that party, and in addition, it is a close corporation, a member or employee of that close corporation. Number 2, any member of that party's registered trade union or registered employers organization or an office bearer official as defined in the Act, or an office bearer or official as defined in the Act of a registered federation of trade unions or registered federation of employers organizations. Number 3, if the party is a registered trade union, any member of the trade union or an office bearer or official as defined in the Act and authorized to represent that party, or an office bearer or official as defined in the Act or registered federation of trade unions and authorized to represent the party. Or 4, if the party is a registered employers organization, any director or employee of an employer that is a member of that employer's organization, or an official or office bearer as defined in the Act and authorized to represent that party, or an office bearer or official as defined in the Act of a registered federation of employers organizations and authorized to represent that party. Number 5, if a party is the Department of Employment and Labor, any employee or official of the Department of Employment and Labor. B, subject to sub-rule 1C, in any arbitration proceedings, a party to the dispute may appear in person or be represented only by 1, a legal practitioner, 2, a candidate attorney, 3, an individual entitled to represent that party at conciliation proceedings. Then we move to C. If the dispute being arbitrated is referred in terms of section 69, subsection 5, 73 or 73A of the Basic Conditions of Employment Act, or is about the fairness of a dismissal, and the party has alleged that the reason for the dismissal relates to the employer's conduct, to the employee's conduct or capacity, a party is not entitled to be represented by a legal practitioner or a candidate attorney in the proceedings unless 1, the commissioner and all the other parties consent. 2, the commissioner concludes that it is unreasonable to expect a party to deal with the dispute without legal representation after considering A, the nature of the questions of law raised by the dispute, B, the complexity of the dispute, C, the public interest, and D, the comparative ability of the opposing parties or their representative to deal with the dispute. Number D, In any facilitation of a large-scale retrenchment, as contemplated in Section 189A, subsection 3 of the Act, a party may appear in person or be represented by 1. A director or employee of the party, and if a close corporation, a member or employee of that close corporation. 2. Any member, office bearer, or official of the party's registered trade union. Or 3. Any member, office bearer, or official of that party's registered union or a registered employers organization. E. No representation by legal practitioner or candidate attorney shall be allowed in facilitation of large-scale retrenchment as contemplated in Section 189A, subsection 3 of the Act. F. No person representing a party in proceedings before the Commission in a capacity contemplated in Sub-Rule 1A or B, other than a legal practitioner or candidate attorney contemplated in Sub-Rule 1B, I, may charge a fee or receive a financial benefit in consideration for agreeing to represent that party. Very important, that one, guys. Take note of that. 2. The party to the dispute objects to the representation of another party to the dispute or the commissions or commissioner suspects that the representative of a party does not qualify in terms of this rule. The commissioner must determine the issue. The commissioner may call upon the representative to establish why the representative should be permitted to appear in terms of this rule. 4. A representative must tender any documents requested by the commissioner for the purpose of Sub-Rule 3, including constitutions, pay slips, contracts of employment, documents and forms of recognition, agreements, and proof of membership of a trade union or employers' organization. Despite the provision of Sub-Rule 1, a commissioner may exclude any person who is representing a party in any proceedings or on the basis that they are a member of the same employers' organization as an employer's party or a member of an employer's organization that is a party to the proceedings, if the commissioner, after inquiring into the matter and considering relevant representatives, believes that A. The representatives joined the employer's organization for the purpose of representing parties in the commission, or B. The representative's participation in the dispute resolution process 1. Will be contrary to the purpose of the rule, which is to promote inexpensive and expeditious dispute resolution in a manner that is equitable to all parties. 2. Is not keeping with the objectives of the Labor Relations Act 66 of 1995. Or 3. May have the consequences of unfairly disadvantaging another party to the dispute. 6. Despite the provisions of this rule, but subject to the provisions of Sub-Rule 1, subsection F, the Commissioner may, on application brought in accordance with Rule 31, allow a person not contemplated by Sub-Rule 1 to represent a party at arbitration proceedings before the Commission after considering A. Whether it is unreasonable to expect the applicant party to deal with the dispute without representation after considering the factors set out in Sub-Rule 1C. B. The reason why a person contemplated in Rule 25 cannot represent the applicant party, which includes affordability if applicable. Okay, guys. I think for now, then we'll cut it there. We'll cut it there. Then in the next video, we'll continue with chapter 5 or part 5 of the CCMA rules, the new CCMA rules, because it's quite long. So just try to keep it short now. So in the next video, then we'll proceed to the second part of part 5, because it's quite long, guys. So just keep that in mind. The next video that will come up is the video that deals with the second part of the part 5 of the new CCMA rules, guys. Thank you very much, guys, for tuning in. Thank you very much, guys. Please subscribe at the bottom of the video. There's a subscribe option. Please subscribe. Please share with others. Share on your different platforms, Twitter, Facebook, whatever social media platform that you are using. Please share on it, guys. Thank you very much, guys. Listen.